Hi, I'm Beth Walensky, legal practice professor at the University of Michigan Law School. This video is about the E in CREAC. That's the explanation step. Now remember, explanation is the step that comes immediately after you've stated the rule or rules you're going to use. It uses the cases to explain to your reader how the rules operate in practice. Now, like some of the other videos for CREAC, this one does contain a lot of text in some places, so you should always feel free to pause the video if you want to spend a little more time reading through the text. So let's talk about explanation. First, what are the purposes of explanation? Why do we even use the cases to draw out more information about the rules? There are two main reasons we do this. The first is that the explanation provides evidence to your reader that you're actually correct, that the rules that you have synthesized are authentic and legitimate rules based on the case law. The second reason we explain the rules is to illustrate the rules for our readers, to take the rule that we stated and to make it concrete by showing how courts actually use the rule in practice. Keeping those purposes in mind helps us figure out which cases to use to explain a rule. Now, sometimes you may have stated a rule that you synthesized from two very significant cases, and so it will be obvious to you that you need to use those two cases to explain the rule. Sometimes, however, you have more choices about which cases to use. So one thing to keep in mind, not just for the explanation part of CREAC, but with everything you write for a legal audience, is that your goal should always be to provide all of the necessary information your reader needs and no unnecessary information. So what does that mean? Well, when we figure out which cases we want to use, it's a helpful guiding principle. So first, I want cases that actually help illustrate how the rule operates, that take the rule and using the facts of those cases, make it more concrete. Second, I want cases that add to my reader's understanding of the rule. If I have 4 different cases that all do kind of the same thing, that help explain how the rule operates in very much the same way, I probably don't want to throw all of those cases at my reader. I want to pick those that do either the best job of illustrating the rule or are from a jurisdiction that's binding, or sometimes I might have cases that reach different results because they use the rule and apply it and produce different results. So for example, I might have a case where the application of the rule in that court decision leads the court to find that a factor is satisfied, and another case in which the application of the rule leads the court to find that the factor is not satisfied. And it would often be very helpful to my reader to show both of those cases. And I'll have an example of that in just a little bit. So let's look back at our imminence element. If you remember, we have a full paragraph that I wrote showing how the full CREAC analysis works. Here we have just the rule and explanation. As you may start to have started to figure out, rule and explanation kind of go hand in hand. So our rule, remember, we have a 2-sentence rule, which is that an action is imminent even where it is merely close rather than touching, or at least near at hand. Where the victim has a weapon within arm's reach, the harm is imminent. Now I want to explain that rule for my reader. I want to make more concrete and illustrate what it means to say the weapon is within arm's reach. And I use the explanation to do that. Here, the explanation is 2 sentences. For example, in Juneau, the victim had a gun strapped to his leg. The court held the victim's ability to quickly reach down, grab the gun, and shoot it satisfied the imminence requirement. Now let's look a little more closely at those 2 sentences of explanation. So remember, our guiding principle in what to include in the explanation is that I want to include all of the necessary information, and I don't want to include any unnecessary information. What does that mean here? Well, I started with 1 sentence that contains the facts. If my reader, after reading the explanation I offer of a case, has to go pull up that court opinion and read it herself, then I haven't done my job. I need to include in the explanation everything my reader needs in order to understand how this case operates at this point. Usually, that means that a nice default place to start with the explanation is 2 sentences. The first sentence, which states what the key facts of the case are, and the second sentence, which states the court's holding and perhaps the rationale, the reason the court reached that holding based on the facts. And that's what my second sentence does. Now, a few other things about this particular explanation that help draw out some other principles that you want to follow when you're writing an explanation. Notice, first of all, that I'm focused only on this element. In this part of the memo, I have a CREAC for just the imminence element. It's not helpful to my reader if I start throwing a lot of detail about this case in that doesn't have to do with the imminence element. Don't worry, there is a good place in the memo to talk about the bigger picture, to talk about how all of the pieces fit together. But when we're in one specific element or factor, I want to focus just on that. So I've provided only the facts that are relevant to this element, and I've provided only the court's holding for this element. Finally, notice that I've used descriptive labels to identify the parties. I've called Albert Miles, remember he's the individual who was the aggressor in this interaction in Juneau when this couple had left this restaurant in Flint. Instead of identifying him by name, I call him the victim. That's how the self-defense cases identify the person that the defendant, the criminal defendant, in this case Mr. Juneau, shot or hurt. So here, my reader doesn't need to know the names of the individuals in the case. That's unnecessary detail that can end up being confusing. It is very helpful to use descriptive labels. So if I had a case about a bank loan, for example, I might identify the parties in the case as the lender and the customer. In a landlord-tenant case, I would identify the parties as the landlord and the tenant. That kind of information is a much more helpful way of identifying the individuals in a court decision rather than using their actual names. And one other thing I want to show you before we move on to a new example of explanation is what not to do. Remember, again, that we're trying to use the explanation to help our reader understand the rule. It is not helpful to use the explanation to merely restate the rule as the holding of a case. What do I mean by that? Let's look again at our rule. An action is imminent even where it is merely close rather than touching or at least near at hand. Where the victim has a weapon within arm's reach, the harm is imminent. And here's the explanation that's not so helpful. For example, in Juneau, the victim had a weapon within arm's reach, and the court held that the imminence element was satisfied. So why is that explanation not especially helpful for my reader? All it does is repeat the language of the rule without actually illustrating the rule. I've simply taken the language of the rule and said, here's a holding in a court case that actually used this rule. So that's not a helpful way of using explanation. So now let's look at another example, this from the great bodily harm element. This is an example of how you can take the explanation and in some limited circumstances make it even shorter to provide your reader with just limited information that he or she needs. So remember that we've synthesized this rule for great bodily harm. The defendant can satisfy this element even where the victim didn't have a traditional weapon. Hard, everyday objects used as projectiles or bludgeoning devices can inflict great bodily harm. And here's the explanation. For example, courts have found that folding chairs and frying pans are both objects capable of inflicting great bodily harm. Notice that really all my reader needs is those two quick examples of two different household objects that can be used to inflict great bodily harm. And I can get all of that information easily into a clear and succinct sentence. So usually you want to start with a default of 2 sentences. Occasionally you can use 1. Frequently, however, you need a lot more information about a case for your reader to be able to understand it. So let's look at some more complicated examples now. So you may recall from the last video that this was one of the rules for reasonable belief of harm that I synthesized. Where the victim had already initiated an attack and not unambiguously ended it, a defendant's belief that she faced harm is reasonable. So this rule, note, is one that I synthesized. It's not a rule that any of the courts stated explicitly, but when I read the cases, I realized that this was a basis on which some of the cases came out differently, and that's how I came to this rule. So now I'm going to explain the rule using those 2 cases that ended up with different results for this element based on how they applied this rule. So this is my first case explanation for that rule. Notice, first of all, that I need 3 sentences just to get the key facts out. That's because this is a more complicated case, and the facts that my reader needs for that first element are more in-depth. In People versus Sanderson, for example, the victim arrived at the defendant's home drunk and angry, yelled at the defendant, and shoved him against a wall hard enough to leave a large bruise. The victim then went to the next room and picked up a folding chair, yelling to the defendant, "I'm not done with you yet." The defendant then hit the victim with a fire iron. So those are the facts. I then need 2 sentences to convey the court's holding and the reasoning, the rationale, the reason the court reached that holding. And here are those 2 sentences. The court held that it was reasonable for the defendant to believe the victim may have been about to throw the chair at him, in part because it wasn't entirely clear what the victim intended to do with it. The victim was still angry, yelling threatening things, and picking up a potential weapon. So here's the second case that I'm going to use to explain that same rule. Remember, in this case, the court's determination of whether this element was satisfied came out the other way based on the operation of this rule. I start with the word however. That's a helpful transition word that signals to my reader that this case has a different role than the previous one that I just discussed. Transition words can be really helpful when they are used properly. They can also be overused a little bit, so use them thoughtfully. Then I have an initial sentence which orients my reader. It provides a general statement of the holding. Again, sometimes that's helpful when I'm moving from one case to a next and I want to explain to my reader what the key point is from this case. Next, I have the facts, and here I use 4 sentences just to get the facts of the case out. Remember, I want to make sure that my reader can understand everything she needs to know about this case just from what I say. So that's why I need 4 sentences of facts here. So here are the facts. That's in the case People versus Crabapple, a customer at a department store became angry when she was denied a discount she thought she was entitled to. She yelled at the defendant, who was a cashier at the store, became increasingly more angry, and then threw a large pot at the defendant's feet. The manager finally arrived and granted the discount, which calmed the customer. The customer turned to leave, but stopped to check the price tag on a frying pan, at which point the defendant stabbed the customer with a kitchen knife. Then, I only need 1 sentence for this particular explanation in order to convey the court's holding and reasoning, and here's what that sentence is. The court held that the defendant's fear that the customer was going to attack her with the pan was not reasonable because every indication was that her aggression had run its course. You may be wondering where all of this fits in a larger CREAC for the element. So here's what it would look like. Now, remember, we're assuming that this is just one of the rules that I'm explaining for the reasonable belief of harm element, and that I've already stated a conclusion and probably stated and explained some other rules. So then I have this rule that starts up here. Now, rules are often really effective topic sentences for paragraphs that explain the rules. Because the explanation here is pretty lengthy, there are 2 cases that need some detail to discuss, I put them in 2 separate paragraphs. Frequently, however, if I had shorter case explanations, I could probably put everything in 1 paragraph. In other words, I could have 1 paragraph that had the rule as the topic sentence, and then all of the explanation from the 2 cases in that same paragraph. And notice at the bottom, I'm ready to go on to my next rule in a new paragraph where I'll start with a topic sentence that states the rule, and I would then explain it. So what you might have already gleaned from this, I'm going to make a little more clear now. When you have more than 1 rule for a particular element, how do you organize that information? So here's what you don't want to do. You don't want to state the conclusion and then state all the rules and then state all the explanations and then apply it. In other words, you usually want the explanation for a rule to immediately follow your statement of the rule. So you'll have your conclusion, you'll state a rule and you'll explain it, you'll state another rule and explain it, and if you have a third rule, for example, you would state and explain it. Remember, I said that the parts of CREAC are building blocks, and sometimes we alter the organization slightly. This is your first example of where you can take those building blocks to help your reader really follow along with your analysis in a very clear way. And that's an overview of the explanation part of a CREAC analysis. In the last video on CREAC, we'll look at application and counter-analysis in some depth.